All right. Well, Davis, I appreciate you being here. My name is John Watts. I'm a VA accredited lawyer in Alabama, and we have Davis Nelson, who is a VA accredited lawyer in Georgia. And Davis, thanks for joining us.
My pleasure, John. Good to see you, sir.
Yeah, you too. And so our plan is to try to do these maybe every Friday and to really focus on this benefit, the VA pension or VA aid and attendance benefit. And let me just give a real quick summary and then we'll start into the questions. That's really, Davis, you and I talked about this. That's the whole point of these, is to answer questions. Now, I've got a whole list of questions that people have sent in, and then we may have some folks that are live as well. So just by way of quick summary, this is a benefit for veterans or surviving spouses of veterans. And this is what's called non-service related. So it's not being shot or injured while in the service. It's a benefit that we can give for having served, and it's for wartime veterans. And we'll talk about that, Davis, I think, in some detail. What is a wartime veteran? But the whole purpose is to pay for long-term care. And this can pay up to $25,000 a year tax-free for long-term care. So it's really an amazing benefit and just a lifesaver for a lot of veterans and surviving spouses. So, Davis, why don't we start off with just kind of a quick summary in terms of the requirements. And you and I like to break it down into 3 requirements. So we've got a military, a health or disability requirement, then a financial. So tell us about the military requirement.
Well, to be eligible in the first place, not every veteran is eligible for the benefit. It's only those who served during wartime. Now, that doesn't mean that the veteran needed to serve in a combat zone or be in combat. Merely service during the wartime period is enough to be qualified. And all you need actually is 1 day of wartime service to become eligible for this. In addition, though, you do have to, older veterans basically have to have served 90 consecutive days of active duty service. And generally, training time doesn't count towards your active duty service. So the 90-day requirement of continuous service, the 1 day of wartime service, and that veteran is potentially eligible for this particular benefit.
Okay, and Davis, there's also a requirement about your discharge. Tell us about that.
Yes, the veteran's discharge must have been better than dishonorable. And what that means is that if you have an honorable discharge, or if you have a general discharge, you have a medical discharge, whatever variety you have, it's okay as long as it is not dishonorable. Or there's one limited exception. This is the one we see the most often, is people who have a general discharge, but accepted that in lieu of being subjected to a general court-martial. If that's the nature of your general discharge, then that is the tantamount to being a dishonorable discharge.
Okay. But if we are a veteran with better than dishonorable discharge and we had 1 day of active duty during a time of war and that 90 consecutive days of active duty, then we should meet this requirement. And I guess that brings up the question, Davis, before we finish up this first requirement, what does that mean, a period of war or a time of war?
Well, the VA has designated the dates of certain wartime periods. For example, the period for World War II is basically from Pearl Harbor through the end of 1946. So even though hostilities in World War II ceased in late spring of 1945, most veterans as part of the wind down of the war, were required to stay in the service, like my own father-in-law, who served up until about October and November of 1946. that's still considered a wartime period. The other main ones, of course, are the Korean period, the Vietnam, and then since the first Gulf War, the war on terror has actually extended up until the present day. So we're basically have been in a wartime period here for the last 20 years or so.
Yeah, and that's the longest period of war we've ever been in, I guess since 1990,
Yes.
right?
Correct.
So 20,
Yes.
26 years now. So most of the people I know that I see, and I think this would be true of you, we still have some World War II veterans or widows of World War II veterans. A lot of folks from Korea. Now we're starting to see a good number of the veterans, men and women, from Vietnam War. Is that what you're seeing?
Yes, absolutely. As a matter of fact, I was just looking at some statistics in the last few days here about the what has happened here very recently is that because the older veterans are generally dying before the younger ones, that we now have about the same number of survivors of World War II as we have of Korea, even though Korea was actually had fewer men in uniform. We had a lot, but we've got about the same number of survivors of those two wars that are alive today.
Okay. So that's that first requirement of military. The second one is disability. Give us the quick summary on that.
Well, first, as you said, John, this particular benefit is one that was actually earned as part of the compensation of the veteran during their service. But that benefit was actually earned many decades ago. But usually what happens is the veteran isn't eligible until there's a medical need for it. And that typically will be, in the case of our World War II veterans, we're talking about that the benefit was earned 70 years ago, but they're only now, many of them, becoming eligible for it. So basically, your health has to be such, as a practical matter, your health has to be such where you need, there are really two main ways that people become eligible from the medical standpoint. The first is if the veteran or the other claimant finds that has has dementia of some kind, for example, that will automatically give them the kind of medical rating they need to qualify for this particular benefit. The other way, typically, and this is much more common, is that the veteran or the other claimant finds that they have physical needs for their care. So the kind of care that they need day to day to get through their lives is not really medical care. It's what the VA calls, and there's a similar idea in the Medicaid law, that is, they need assistance with their so-called activities of daily living. And this includes things like they need help with bathing, dressing and undressing, transportation so they can get to the doctor and get around to other things that they need to get to the grocery store, that kind of thing. But they're in need of the assistance of somebody else to get through their day. And as a result, the medical rating that leads to this need, and which the VA will give to the veteran or the other claimant, is the name of it is aid and attendance. That is, they need the aid and attendance of some other person to help them live a normal life. And so those are the two main ways are the mental competency issues. And then on the other hand, are those things about getting the care they need for their activities of daily living.
Okay. And that's why, and you and I have talked about this before, that's why, even though this is really called the VA pension or improved pension, most people know it as just aid and attendance, which is really just a part of it, but it's the dominant thing. So that's why we call it aid and attendance.
Absolutely. As a matter of fact, if you go into Google and do a search for VA pension, you come up with far fewer results, which is pension being the official name for the benefit. It's actually pension or improved pension for the veteran, and for the widow, it's known as death pension. But those are much less commonly used references when talking about the benefit. But it seems like if people know anything about the benefit, they're calling it aid and attendance, which, while technically not correct, it really refers to the medical portion of the evidence that someone needs. But that's the most commonly used term.
Okay. So we've talked about the military requirement, disability. Give us a quick breakdown of the income, or we might say the financial requirement.
Right. Yeah. The two major requirements financially are that your income can't be too high, and the other is that your net worth isn't too high. The income is the one that gives most people the problem for several reasons. But basically, the way the benefit works is that if your income is too high or above a certain amount, then the VA will not pay you any benefit at all. If your income is less than the maximum allowable pension for your particular category, but it's still a positive number, then the VA will pay you the difference to bring you up to that minimum amount to help you with your care. And then if you're to get the full benefit, that is every dollar that's available, basically you have to have a negative income. And by that I mean that your gross income reduced by certain medical expenses is less than zero. That's the only way anybody earns the maximum benefit. The other aspect that makes this difficult for people on their own is that I hardly ever find anybody who knows how to make the calculation correctly. And when I say just about anybody, I mean people who ought to know better, including lawyers and other VA accredited agents. No one knows how to make the calculation. So I always caution people this way, is that you should be able to determine before you ever file a claim, one, whether you're eligible, and two, how much your benefit is likely to be. And if you don't know those things, then I say you shouldn't file until you do know. Because if you file, I always think about it as you sort of throw something against the wall to see if it sticks. And what happens is that people will file a claim and then wait months and months, sometimes years, only to be denied for benefits. And so they've wasted months of lost benefits. So it's very common that we'll talk to people who have lost $20,000, $30,000 worth of benefits because they didn't first discover how much they were likely to earn in benefits. And I can understand that because the actual calculation is rather complex, and most people are not going to be able to figure that out on their own.
Yeah, and before we move to the assets or the net worth, I just want to come back to the income. So for a married veteran, how much does this benefit pay maximum?
The maximum available pension for a married veteran is $2,120 a month, tax-free, or just slightly more than $25,000 a year. The single veteran, divorced, widowed, the single veteran can earn up to $1,788 a month, and then the widow can earn up to $1,149 a month. So it can be a significant amount of money for many people. And we find that for our particular clients, it really transforms their lives for the better.
Right. And so let's take that single veteran, what'd you say, 2,120?
For the married veteran, it's $2,120, or just a little more than $25,000.
Okay. So we've got, let's just call it $2,100. If their income after you deduct everything is $1,100, well, then they would be paid $1,000 a month.
Correct.
Okay. And so the idea is if we can do it legitimately and have the medical expenses that the VA allows, we want to get that effective income down to zero, right?
Correct. Yeah. And it's sometimes people hear me explain the way that the calculation actually works, and it's almost unbelievable, is that so we very often talk with a widow of a veteran who can earn up to $1,149. So if her income is greater than that, I have to tell her your income is too high to earn any benefit at all. And that's why the vast majority of the people that we talk with need some kind of planning in order to earn the benefit. And in the process of that, typically we should be able to earn them the entire maximum amount of $1,149 for the widow.
Yeah, and as you mentioned, when you and I work on cases together, and we pretty much work on all of our cases together, we don't ever want to file a case without knowing, one, will we be approved? And number two, are we going to get the maximum amount?
Absolutely. And if I can just digress a little bit and just give you a good example that just came up here in the last month or so, in which someone I've known for a while who is a CPA, is a very smart guy. He tried to handle his mother's case. His mother was living in an assisted living facility, and he spent over 2 years working on his mother's case before the VA denied his claim in the entirety because his mother's income was too high. And I had to explain to him that before you filed, I could have spent 20 minutes with you and told you that there was absolutely no chance whatsoever that your mother's claim would be approved as he was going to file it. But that we could have easily qualified her and earned her the maximum benefit. So in his case, he's actually going to, in the case of his mother, by the time we got around to kind of fixing the problem several months later, it's cost him nearly $35,000 in lost benefits.
And let me just say this, because I can imagine somebody's watching this and they say, well, sure, it seems like a good idea to get with a professional, get with a VA accredited lawyer, but I don't just have a bunch of extra money to spend to find out the answer. So when somebody contacts us, and I know you and I do the same way, do we charge them just to talk to them or to give them an opinion about whether we think they would qualify or not?
Two things about that. One, to talk with you and to give you some feedback on whether you're a good candidate or not. We do not charge for that at all. We found that is too burdensome for the vast majority of the clients that we talk with, so we do not charge for that. And the other thing we try to make the whole arrangement as risk-free as we can possibly make it and still comply with all the laws that we're subject to. So I don't think people ought to listen to anything we say here and just rule it out and say, this isn't something that I want to do because I know I can't afford it. I think that would be an error in most cases.
Yeah, and we deal with veterans who have tremendous resources, and we deal with veterans and widows of veterans who basically have nothing. And there are ways we can help everybody with that. So I tell you what, why don't we might say for the next, what do we call them? These are blabs, I guess, that we're doing. Maybe we'll save going into the net worth for the next one, because I wanted to get to some questions, if that's okay with you, Davis.
That's just fine.
Okay. Well, one question we got sent in, if my husband was a wartime veteran and died, can I get surviving spouse benefits under the pension? And I'll give you a little bit more sort of context to that question. Her husband had never applied. He was in great health and just died suddenly. And so he was not getting the benefit. So her question was, well, if he never got it, can I now get it? So how would you answer that?
Well, the answer to that, the basic question is yes, you can still get it. The fact that your late husband never claimed the benefit has no bearing at all on whether the surviving spouse can get the benefit. As long as the spouse has not remarried, and as long as the surviving spouse can demonstrate that medical need that we've talked about, then she's potentially eligible for the benefit as well. Now, if she were to remarry, then she will lose the right to that particular benefit in nearly every case. There are some very narrow exceptions, and we see those very rarely, once every 4 or 5 years, maybe at the most. So, yes, for most people, they can get that benefit regardless of whether the veteran ever claimed it. In fact, I would say probably about half of the surviving spouses that we talk with, their late husband never claimed the benefit.
Right.
Mainly because they didn't know about it.
Yeah, either you don't know about it, you don't need it, and we've talked about this before. We could have somebody that, they serve in Korea, and then in 1980 they die, and then here we are 36 years later, and their spouse has never remarried, and now she has a bad fall or she develops dementia, and it's just not a natural thought to say, oh, you know what, I bet mom can get those benefits because of dad serving in Korea and dying in 1980. It just, we don't really think of it that way. So definitely if you are a surviving spouse, or your mother, even your father, because there are a lot of women veterans, and so it could be the husband as the surviving spouse. Definitely check out this benefit because it'd be very helpful. Let's see. Our next question is, well, I tell you what, let's jump to this one. And when this was asked of me, at first I thought, well, that's kind of a surprising question. Then I realized, well, no, it's actually a very good question. And the question is, do the VA benefits, including this aid and attendance, apply to women veterans?
The answer is yes. And as a matter of fact, if we have the situation of two veterans married to each other, then actually both of them, if both of them are medically needy, can get the benefit. And the amount of the benefit will actually be higher than it would be, say, with a one veteran household. So I gave you the number of $2,120 for a married veteran. If we have two married veterans, both rated aid and attendance, then the amount actually is pretty close to about $2,600 a month.
Right. Okay. Well, very good. Let's see here. You kind of covered this, but I want to stress this again because to use the language of this law, we have to use the phrase wartime veteran. So the question is, do you have to have been in combat to qualify as a wartime veteran? Because the name kind of suggests you were, in a war.
Right. That's an assumption that a lot of people make when they call. That's one of the top 3 or 4 questions that we get from people when we talk to them the first time. And the answer is no. They do not have to have been in combat. They don't have to have been assigned to a war zone. In fact, I always like just use the example, if all you did was ride a desk at the Pentagon during wartime, that will qualify you for this particular benefit.
Right. And there may be some particular benefits that are unique to folks who have been in combat or injured in combat, but this is not one of those.
That's correct. Yeah. As a matter of fact, the only thing, there's one question on the main application form, in which there are a number of different forms that have to be filed, but the main application form does have a question on it where it asks whether you were ever a prisoner of war. And the reason they ask that question is that they do give priority to the deciding of your claim if you were a POW.
Right. Okay. Let's see. Our next question is, and and I'm not sure, this may take you a couple minutes to answer, but should a veteran file an informal claim, or instead should they file what is called a fully developed claim? So maybe if you could first define what is informal and fully developed, and then help us to know, should we file this one or should we file the other one?
Okay, that's an excellent question, and it's not the easiest one to answer. And let me give you a little background. The main reason people file an informal claim is they want to lock in the earliest possible date for benefits, because here we are in February. So if I file a claim in February, then whether it's a formal or an informal claim, that will lock in the effective date of benefits of March of 2016. So every month you wait to get your claim in is another month of benefits you lose forever. So you want to do what it takes to lock in that early award date, if at all possible. And many people say, well, I ought to lock in my claim by filing an informal claim, and then that gives me a year in which to supplement my claim and get the entire claim finished and in the hands of the VA. Originally, when we started working with this with this particular benefit, we would look at people's claims and figure out those that we thought we wouldn't have trouble completing and filing the formal claim later. We discovered an interesting thing, is that whenever we filed an informal claim, it somehow sapped the energy from the client. And as a result, the filing of these claims would drag out for months, and sometimes we would find that the year would expire without us having gotten all the information we needed, even though we had been urging our client to give us the information that we needed. And what happens after that year, the VA will conclude that they're not going to get anything else, and they will deny the claim. And so you've lost a year, and you're not going to get anything at all. So our policy has become that we don't file informal claims at all. The other part that is a risk is that very often people on their own will file an informal claim and then not knowing whether they qualify at all. So you may have just filed a claim that is going to be denied because they're going to determine your eligibility as of the time you filed, not later on when you finally supplement your claim and the claim becomes a formal claim. So there are a lot of risks associated with filing an informal claim. And that's why I say overall, our clients have gotten better results by us following that policy rather than trying to get it in early. So sometimes we may miss months. So if we get a new client in the second half of the month, it's unlikely that we're going to be able to finish that claim before the end of the month. But so it may roll into the next month. But overall, I think our client will thank us because they will not be in a position of having waited a year and have it expire. So it's just overall, it's worked much better with us to file only formal claims. Now there may be situations where it's right, but the way we do things has just worked much better for our clients.
Okay. Well, thank you, and want to welcome any new folks that are joining us here. We're talking about the VA pension or aid in attendance to help pay for long-term care. And Davis, appreciate you answering that about, informal claim, formal claim, and I agree with you. Even though there are maybe some times where an informal claim seems attractive, I know you and I like to file that fully developed claim and then make it so it'll go through as quickly as possible. And so appreciate that. The next question we have, and if anybody who's on this broadcast has a question, just feel free to type that in or let us know. Otherwise, we'll work through some more of these ones that were submitted ahead of time. Do you have to be in a nursing home to qualify for the VA aid in attendance?
No, you don't. As a matter of fact, I would say that somewhere in excess of 95% of our clients, the reason they like the benefit is because it allows them to continue at home, live at home, and still get the care that they need. And this extra money, first, the most common way we see it used is to allow them to continue to live at home. And the second thing is it often allows people to be able to afford an assisted living facility, or maybe to move to a private room in the facility. So it's very rare for us to see it used to pay for nursing home care. Most people are going to rely on Medicaid for that. So just about all of our clients, right now I'm trying to think, I don't think we have a single client receiving the benefit who is actually in a nursing home. They're in some other arrangement. They're closer to where they want to be.
Right. And the only time that I have used it for a client in a nursing home is if we have somebody in a nursing home, and we're not going to get into all the Medicaid rules, but for some period of time, we cannot get Medicaid benefits. So we use the VA pension or aid and attendance to bridge that gap. And but yeah, like you said, most of the time we want to stay at home. And if we can't stay at home, we want to be in assisted living. And yeah, that's, as you and I use it, this is the whole point of using the benefit, is let's stay out of a nursing home if at all possible. Now, if medically we have to be there, then we do that, but otherwise let's stay out of it. Let's see here. I see a question. I've been trying for VA help for 2 years for a 91-year-old 7-year combat veteran from World War II in Korea. He gets stuck on someone's desk every time they make a move or every form they send in. And so definitely understand that frustration. And Davis, if we're going to assume that is for a VA pension application as opposed to the service related. Unfortunately, service related, it just takes sometimes years and years. But what suggestions would you have for somebody filing the aid in attendance where it seems like they can't get any traction on it?
Okay, really great question. And there are a lot of aspects to this. There is and I have to explain one background thing here, is that there are two types of claims for VA pension that get filed. The type of claim that we file is, it's called the fully developed claim. I refer to it as the fast track system. And that is, when we file a claim, we file this so-called fully developed claim. And the idea behind this claim is that we are saying to the VA that we are giving you absolutely everything you need to decide the claim. So you should not come back to ask us any additional questions or ask for additional documentation. So we know what should be filed, and therefore there should be no delays of any kind. You just sit down with the claim and go through it and approve it. And that's why, at least until fairly recently, most of our claims were being approved in about 2 to 4 months on a reliable basis. Some takes longer, some less, but that's on average what we've been experiencing. But most people, the do-it-yourselfer, what they're doing is filing what is, for lack of a better name, let's call it the regular system. And there is one reason that they tend to do, or two reasons. One, they don't know any better about that there are alternatives available. And that the other part is that if you file that type of claim, the VA has a legal obligation to assist you in gathering information. When we file the fully developed claim form, we're telling the VA we don't need that, so we're not going to be asking for your help. Decide the claim on what we've given you. The other person who files this regular claim, they're saying, I don't know what to file, so I'm just writing you a letter saying I want to apply for the benefit, help me out. And those kind of claims typically are going to be take at least 3 times as long as a fully developed claim for a decision. And in fact, is very common for these types of claims. So in getting that, the cost of asking for the VA's help is that it's going to take probably in the neighborhood of a year or maybe up to 2 years before the VA will actually make a decision. So if you file that kind of claim and then in month 10, the claimant dies, no money is ever going to be paid to anybody, not to the estate of the claimant or to the family. And so they'd have lost all that money. So there's a real premium on filing the fully developed claim as opposed to this regular claim. So there's a huge price that can be paid for asking the VA for help. So that's why we follow the fast track system that I described.
But if we file the regular claim and it just, it seems like it's moving very slowly, is there somebody we can call? I know you and I have talked about sometimes we'll reach out to a senator, a congressman. Sometimes they can magically get it moved a little bit closer to the top of the pile.
Correct. It does appear that when we have called and on behalf of clients and contacted senators and members of Congress, that on occasion that has the effect of kind of shaking loose a stuck claim. Not all the time, but it does on some occasions. Especially one particular senator here in Georgia who's no longer in the Congress, his office seemed to do a really good job of helping us with those. And there have been several cases where within days of the inquiry by the senator's office, we were getting a decision from the VA. But there's no guarantee about that. The best thing you can do is get all the evidence in as quickly as possible. The other thing I wanted to mention is that here last year, we were getting claims in as few as 3 weeks. Those days appear to have disappeared this year. And I just was talking to somebody at the VA here last week, and he was telling me that why we were getting such good results and we seem to be seeing longer periods of waits this year is that last year the VA was paying overtime to the reviewing officers to try to work off some of the backlog. And this year, the ability to pay these people overtime, that is ended. And as a result, we're seeing some significantly longer times that clients are waiting. So it's just the big backlog. And remember, there's a big backlog for this benefit, but in the scheme of things, this particular benefit is really small potatoes in the eyes of the VA, because the service-connected benefit is a much, much larger program. So it tends to get more attention. It gets more, you hear more about it in the news, and therefore it gets more emphasis by the VA. So this is kind of a forgotten program, if you will, at the VA.
Right. Well, and the person had asked that question, it looks like they've had the American Legion helping them, congressional help. Still, they're getting delays here. And then there's a follow-up question: what is a fully developed claim? And Davis covered that a few minutes ago. I'll just summarize it quickly. It's where let me tell you what the opposite of fully developed claim would be: an informal claim. That could be as simple as one document to the VA saying, I'm going to make a claim. A fully developed claim says, here's my entire package. I have everything that you want, every piece of paper, every document. It's ready. You don't need to come back to me to ask me for anything else. I don't need your help, VA. Here it is. And so ultimately we make a choice. Do we do this informal or fully developed claim? And advantages, disadvantages to both, but Davis and I in our practice, we, I guess almost exclusively, I could say, do the fully developed claim. So hope that answered the question there. And Davis, do you have anything to add to that?
Yes, I do. I want to clarify one thing, is that there can be an informal claim for either the fast track fully developed claim, or there can be an informal for what I refer to as the regular claim. So think of the regular claim and the fully developed claim as being the same. They're both formal claims. Okay. What happens is if you want to ask the VA to assist you, then you're going to file a regular claim, a formal claim. And that you're telling the VA, I need your help. And whether you need a lot of help or a little claim, that claim is going to take a long time for a decision, at least 9 months to a year for that. That's why we never filed one. Our clients, being older, they need a decision as quickly as possible. And if they could get the benefit in 2 months versus 10 months, then, and they die in between, there's a huge financial penalty for doing so. So there is a penalty for asking the VA for help. So let me give you an example for a veteran. If the veteran wants to file a regular claim and knows they're going to need help, the main claim form is going to be the 21-527. Okay? And the implication of filing that is that you're going to need help. And that claim is going to go to the bottom of the stack, and it's going to take a lot longer for a decision. If you want to file a fully developed claim, you're going to file a different form, and that one is a 21-527 EZ, for easy, okay? But in that form, that tells the VA, I don't want your help, so I want you to sit down with my claim form as is. But what we tell people, if you think you can file a fully developed claim, it better be perfect. Otherwise, the VA is either going to deny the claim because you left out information, or they're going to take you out of the fast track process and put you back into that regular form. Does that make sense how I explain that?
Yes. Yeah,
Okay.
That's very good. And
Good.
And both those sort of paths or tracks are there, and somebody can choose whichever one they want. But as you point out, if you do the one that says, hey, VA, I don't need your help, well, then we need to make sure that everything is done right. And because the idea is we want that claim to hit the person's desk and they go through and go, yep, everything's there. Okay. And then move it on rather than, wait 3 months and say, we need this one document, and then wait 4 months. Oh, wait, we need another document. So that's what we recommend.
Yeah. And think of it as at the VA, they're going to look at your claim, and if you filed it on a 527, it's going to go in one stack, and that's the one that's going to take a long time. If you file the fast track system, it's going to go into another one, and it's going to get processed under an entirely different procedure.
Okay. Well, we still, you and I were planning on ending this at the top of the hour, so we still have a little bit of time. Anybody wants to type in a question, you can do that. We have some questions that were submitted ahead of time, and I want to go to one of these. What if my mother, who is a widow, is blind, but she can still take care of herself? Does she qualify? Now, presumably, she's a widow of a wartime veteran.
Correct. Someone who is legally blind, and offhand, I can't remember exactly what the medical specification is, but a widow who is legally blind, that is basically a guaranteed aid and attendance medical rating.
Okay. And so, and particularly for people who may just now be jumping on, 3 requirements to qualify. We need a military requirement, a health, and then a financial. So this would meet the health requirement. We still have financial issues that we'd have to qualify, but being legally blind does allow us to meet that aid and attendance standard. So the next question I have is, can my mother get benefits? She was married to a wartime veteran, but then divorced 2 years before he died, and now she needs help.
There is, the general rule is that marriage disqualifies the surviving spouse from receiving this particular benefit.
I guess divorce, right?
Divorce or remarriage. I'm sorry. That will cause the loss of that of the benefit. There is one exception, and it is a date one, where the marriage and that a subsequent marriage and a divorce from the subsequent spouse will be ignored for purposes of the benefit. And I can't remember, the last date is something like November of 1990 or something like that. There was a special law, but there was a big change in the law back in the late 70s. So I may have the date wrong on this, but I've only seen it once in the last 5 years. And I was talking with another lawyer recently, and he said that he hasn't seen a single example of that particular exception that's built into the law in 20 years of doing this kind of work. So it is very, very rare, and it's diminishing over time. But it does exist, and it's worth checking. It's a very obscure law. So when we file this particular claim, we're going to make sure we explain the law to the VA, because I bet you that the reviewing officer will not be familiar with it.
Yeah, because the whole concept of this is you are a surviving spouse.
Correct.
Well, if you divorce, then you're not a surviving spouse anymore. So
right. There's one. If I could just mention one other thing, John, is that not only got to be married to the veteran at the time that the veteran died, you must have been living with the veteran as well, with limited exceptions. You know, let's say that the veteran or you were in the hospital or in a rehab facility, or you were separated because of spousal abuse or something like that. So there are quite a few exceptions to the requirement that you are actually residing with the veteran at the time of the veteran's death.
Okay. Let's see. Here's one I know I get a lot, and I suspect you do as well. Can you get both the VA pension or aid in attendance and VA disability?
The general answer to that is no. Typically, when somebody moves into a nursing home, the vast majority of the folks that we see, they're going to have to rely on the VA pension benefit isn't enough to pay for nursing home. It may help, but it's not going to be enough to pay all of it. So most people are going to have to rely on Medicaid, not Medicare, because Medicare doesn't really cover that. So Medicaid is going to pick up the tab for the nursing home. What happens is that Medicaid is deemed the payer of last resort, and so VA will reduce whatever benefit the claimant was receiving before going into the nursing home and reduce it to no more than $90 a month. There is one exception that I know about where you can get both Medicaid and the VA pension benefit, and that's where you've got a veteran. It wouldn't apply to the widow, but it would apply to a veteran who moves into a certain type of state veterans home. And there they can receive both benefits. But because there's a limited number of beds available in these facilities, it's very, very rare. I see it maybe once every 2 or 3 years, and that's about it.
Okay. And I may not have asked that question the right way, so I apologize for that. What I meant was the question is, can I get the VA pension on the one hand and VA disability for service related?
Okay, that's easier, and that is a common question. And the answer to that is no. You can't get both, but the VA will always pay you the larger of the two benefits. And I might mention that there is one additional benefit known as disability and indemnity compensation, or DIC, for a survivor. And that can actually pay a little bit more than pension, but it's we don't see it all that much. You know, maybe one widow out of 100 gets it. Okay.
Let's see. I think we've got maybe time for one or two more. And this I thought was a very good question, and has to do with long-term care insurance. I know both of us recommend that families at least investigate long-term care insurance. And so here's the question. Dad luckily has long-term care insurance. Will the VA count this as income when we apply for VA pension or aid in attendance?
That's an excellent question. And the answer is yes, they will count it, because the definition of income for VA purposes is very different than it is for income tax purposes. So if you're tapping into a long-term care policy, then the amount that's coming out will be treated as income. But if you're taking it out in order to pay it out to someone else, such as an assisted living facility, then that will be treated as a deductible medical expense. So it may, in a lot of cases that we see, the distribution is coming out and maybe even being paid directly to the facility. In that case, you may have offsetting income and expense items.
Okay. Well, this was not actually submitted to us, but I know you and I deal with this a lot, so I want to pose this question to you. If, let's say that I'm the son of a veteran or a veteran surviving spouse, and I'm providing care for my mom or my dad, can they pay me money to provide this care? And how does that work with that income that we talked about earlier, where we take our gross income and then we bring that down based on medical deductions?
No, that's a great question. The answer is yes, that you can pay a relative, but a requirement for that is that medical rating of aid and attendance. There's actually a lower medical rating called housebound, but it's we rarely see people with that, so it's rather uncommon. So nearly all of our clients get the aid and attendance medical rating. And there are two important factors of that medical rating. The first is that it increases the maximum available pension that's available. And the second thing is it means that you can now pay somebody else, a third party, to provide your care. And typically what we see is that an adult child of the claimant is paying an adult child to take care of them. Or maybe in a few cases it may be a friend, but usually it's a relative, and most commonly that'll be an adult child who's maybe already a caregiver. One caution: paying a relative for care excludes the spouse. So if we have a married veteran, the veteran can't pay his wife for the care and treat that as a medical deduction, because the veteran and the spouse are treated as an economic unit. So in counting income and medical expenses, it includes the income and expenses of both of them.
Yeah, and I suspect you see this also, Davis, when we talk about adult children. At least in my experience, that's 75–80% of the time an adult daughter that we see. And daughter's taking care of mom or dad. Maybe she's quit her job. Maybe she's still working and, just giving up on sleep to take care of mom or dad because there's not enough money. And so how can this benefit help the entire family that's dealing with this situation?
Well, it's very common for us to see the situation where a family member is having to reach into their own pocket to cover the care that a veteran or the widow of a veteran needs. So one of the first things that happens when the benefit starts is that person no longer has to reach into their own pocket to help mom or dad. Very important. So that's a very common thing. So it's a little bit different. When I talk directly with a veteran or the surviving spouse, their concerns are of one kind, about getting the care they need. And then maybe I talk to the adult son or daughter, and they have additional requirements here, and they're worried that they're going to run out of money, or they're going to compromise their own financial future by having to spend money on mom or dad. They're doing it, and they're willing to do it, but they sure like it if we could find a way to get the money so they could stop that practice.
Right. Let's see. We are just a couple minutes here, Davis, and doesn't seem like it, but I think an hour has gone by.
Yeah.
So want to open.
Okay, John, I see you're frozen on the screen.
Open it up if anybody has.
Well, it looks like we just lost John here. I'm not seeing any questions on here. I'd be happy to answer any if there are questions. Looks like I'm now the default moderator here. I think I had just about everything. I wanted to mention one other thing if John doesn't come back on the line. And I wanted to caution people about this because it's one of those errors that I see all the time that people make. And it involves signing documents and using powers of attorney and who can sign on behalf of the claimant. And here's the general rule that people should keep in mind is that that if the form asks for the signature of the claimant, that only the claimant can sign. If you have a state authorized power of attorney, that the VA will not recognize one of those state authorized powers of attorney to sign the VA forms on behalf of the claimant. So one way or another, you've got to find your way to get the claimant to sign the form, or you're going to have a court-appointed guardian sign on behalf of the claimant. And that can be a time-consuming and an expensive process in some states. So, but if there's a way, there is no test of incompetency.
Davis,
John, are you back?
Yeah.
Okay.
I'm not sure where I went.
I was tap dancing here while you were gone. I was actually talking about a topic, and I just